good afternoon to you, Mr. V.R.Shankar, President and General Counsel for Hindalco Industries, Aditya Birla Group. I welcome you to this episode of the Global Resolve Mission Mediation, where we invite influencers and thought leaders like yourself to share your views and perspective about the subject and the concept of mediation. So welcome once again.
Thank you, Sanjeev. Thank you for this.
Great. Okay, so with your permission, I'll put some questions to you, and based on the reaction and the response, then there'll be some follow-ups, and
Sure.
we'll try and wrap up about 30-40 minutes, depending on the convenience, right?
Sure.
Great, thank you. So the first one is the very basic question, what we normally ask to various stakeholders, whether it's a GC like yourself or a party in dispute or a mediator for that matter. What is mediation to you? Is it something more than negotiation?
Very different, from a simple expression of the word itself. Negotiation is where you are still trying to get one way or the other, right? Get the best out of the negotiation for you. Mediation is actually more, it's more equanimous, where you're trying to find a solution to a problem. That's how mediation steps in, right? Negotiation is more, I see my benefit, you see your benefit. Mediation is where we see benefit for both. Is it a win-win situation we can get, where we can potentially avoid a litigation or a dispute to be resolved. So there is already a situation where the parties don't see eye to eye, or there is a difference of opinion, and mediation is a process to get to a common platform where we can find a solution to a problem, which is clearly very different from a negotiation.
Great. So one of the questions which had to follow eventually is something which has already been answered by you. And let me still prepone that, because half of the debate is, do we always look at a justice for a dispute we have, or we actually are interested in a solution? And that's what you in any case answered. But maybe you can elaborate further.
It's very funny the way you use the word justice and resolution, right? I'm not sure they're interchangeable, right? So why are you trying to mediate? That's not justice in your mind, in certain situations, but you want to just avoid getting into a dispute or a long drawn litigation to eventually see justice, right? Is an outcome of a mediation justice? I'm not sure, right? But outcome of a mediation is definitely a resolution. Okay, so I'm not sure I would use both the words at the same breath in the context of a mediation, saying the end result of a mediated process is justice. I don't think I agree to that. But is it a good resolution? Maybe.
No, exactly. So the whole idea to ask this trick question is that as a legal person,
hardly tricky.
So the whole idea is that when we put this question to the parties, they're forced to think, because all this while they have been just attuned or accustomed or conditioned to a concept that we need justice, and when they get justice in the shape of an award or an order or a judgment, they're not happy. So that is where we try and prod them further and say, were you looking at a solution because you knew what a solution would be, making you happy or satisfied, versus a third party? And so that's exactly the reason why we put this back to the stakeholders.
When litigants go to the court, they have a very fuzzy definition of justice in their own mind, because justice is what makes me pleased or happy. That is not necessarily the justice you deserve. That's why you have a judge, who's not involved emotionally into the matter, and he's looking at the facts and the law as it should be, and is handing down an order which you feel is not doing entire justice. Because the definition of justice to begin with was never what was exactly what you deserve, right? I think I need this, that, and the other, and the judge decides, you get one of the three, and you think, oh, justice is not done.
True.
That is not his expectation of what justice is to you. It is justice what it ought to be, right?
True.
Half the time your perspectives are skewed.
Right? Exactly. So the whole idea, perspective, and that's what we try and we try and force people to think afresh that a mediation to us is something which is what you deserve and what your interests are and the needs are. versus a justice where the application of law is based on your rights. So something which is either codified or something which is like part of the civil society, that this is the way. So again, the fairness, the equity, all those factors come in, where once we talk about a solution, quite likely the parties are not looking at a 50-50. Somebody is happy with a 20-80 because otherwise he was not even expecting 10 maybe. And then the simple examples we give about the orange, one party wanted a peel of the orange and the other wanted the rest of the part. So mediator could actually solve it, where once they went to a judge, all he had to do was cut the orange into half and give to both the parties, and both were unhappy. So that was the whole idea, to kind of keep prodding them.
See, maybe we are kind of oversimplifying this. If you look at some of the evolved jurisdictions, okay, where as an attorney in practice, you have an obligation to tell the client in a written opinion on the probability of win or lose. Then it is the client's decision to still advise you or instruct you, saying, I understand that the chances of my winning is less than 50%, but I still want to instruct you to go litigate.
Okay.
Now, the onus is on the person who's at the receiving end, or the litigant, to take a call to say that I know my chances of success is less than 50%, but I still want to litigate. Then the fairness of the outcome is clear to me from the beginning. Okay. Now, the reason why you are highly litigious in terms of, as a jurisdiction in the country, every small issue lands up in the court, because we are not being truthful. When a client comes to me, and am I being clear to tell the client that, given the facts as they are, and the way I see it dispassionately, I think you have more than reasonable chance of winning or losing. And then the client, on an advisement, takes a view saying, I know that I have a more than fair chance of losing. I still want to litigate. The expectation of justice is reset at that stage.
Right.
How many times you come across a situation where an attorney in India tells you that, you brought this brief to me, and on a dispassionate reading of it, I don't think you have one goddamn case. Please don't litigate. Right?
Sure.
You start with that fairness in every brief, and every person a litigant who's coming with a lot more emotion and passion than law, and somebody resets that emotion and passion to say that, don't even go there. You're going to lose a lot of money and gain nothing out of it, and a lot of time and effort of the judicial system, which is only going to result you into more frustration. We can keep easily blaming the courts for saying it takes inordinately long time. Indian judicial system is, completely lackadaisical. It is not fairness. Justice delayed is justice denied, and all that. But let's go to the inception and check. Is an attorney telling me, Sanjeev, don't even go there. You don't have a case. And are you, as a client, willing to respect my opinion and saying, thank you for showing the direction to me, or saying, this lawyer is worthless, let me go to somebody else who's got more aggression in him to fight it anyway. I am multiplying litigation because I don't want to face the fact. I don't want to face the truth. Now, if you go to a mediator in a loose sense to say that I want to go to an independent third party to hand over my brief and say, can you please look into the file and tell me, do I even have a case? And the mediator says, you know what, my friend, don't even go there. You have zero case. Forget it. Right? And do I have the courage to take it saying that, yeah, I agree. Thank you for telling me that I don't have a case and I don't want to litigate. Nothing starts without people putting their emotion and passion into it, where there is absolutely no law in your favor or the facts are against you.
True.
Right? Your litigation will come to maybe less than half. If people, all of us take the responsibility of advising our clients, in candidly saying, you don't have a case, my friend, don't go to court. You go there and say, kuch to karwa denge, ab aap aaye ho to kuch to karna padega na.
True. And the habit of never saying no. Come, we'll do something.
Why blame a system that you have, all of us, you, me, everybody, we have overloaded the system.
Right.
When we say the system is going too slow, of course it is going slow, because we have contributed to the problem.
To the problem. Wonderful. So this answer had tangents in three of the attorney. People who are ideally supposedly becoming gatekeepers of justice, as at times it's been said, that, they say it all, they tell you all, and then they drive the narrative. So is it something which probably is also a cause of concern, that you end up going to attorney and then are guided in a certain way, where you never hear a no? The chances are always that we'll ensure that you win, will ensure that the other party suffers, and hence you should continue. So that was one which clearly comes out. Second is, again, there is a sense of comparison. So essentially, we do not see or evaluate mediation as a concept in isolation for its inherent benefits. It's flexible, creative solutions possible, give and take, and better as to you being the ultimate beneficiary as to what will be of advantage to you and all that. But unless until it is compared with something which is a law, which is a system, which is an overloaded judiciary system, and hence we say, because it's uncertain, because it might take a lot of time, because it's costly, because time consuming, hence come to mediation. So are we not saying that unless until it's compared, and the smaller line is compared with the bigger line, a smaller problem is compared with a bigger problem, then you start appreciating, or you're made to appreciate? Should we not look at mediation as a concept where you are able to save your relationship as well, apart from the whole lot of other benefits? Is comparison by default important day one to start appreciating mediation?
I don't necessarily agree with the approach, Sanjeev, right? The reason why we are more recently talking about arbitration, right from the old Arbitration Act to the new Arbitration Act, mediation now becoming the new buzzword, right? We are getting pushed to it because we suddenly realize that going to court is a hopeless situation. But we have created that situation to start with, okay? If you look at it, we have a very different reality as a country, okay? We have very different evolution of the judicial system, the courts, and the entire legal system. We have a very different reality, right? Litigation is it's inexpensive to begin with. It just becomes expensive as it prolongs. To begin, we don't bat an eyelid because you're saying, that's all it's going to cost, for me to sue Sanjeev. Sure, let's go for it. But by the time I realize what have I started, I've sold all my assets, and my liquidity is gone. Too late for me to realize, do I now pull back? Right? I wanted to claim 10,000. I spent 10 lakhs in chasing the 10,000. It's too late for me to realize it. But that's again going back to the fact that, I can tell you from an in-house counsel point of view that I have an accountability for the decisions I make. Right? If I consistently make wrong decisions, one day the management is going to realize that this guy is no good. They'll ask me to get out. They'll show me the door. Right? Do you, as an external counsel, have the same accountability for the decisions you make? I'm giving you an advice. We'll go and maybe push it in the court and try our luck. And unfortunately, the judge is not with me. I thought that I'll be able to persuade him, but the judge decided otherwise because he's an independent person with an independent mind, and that's the reason why he exists.
Right.
He disagrees with you. I come back and say, Sanjeev, sorry, I tried my best, my friend. We didn't get the result we needed. But now you are left, thinking as a client on what do I do with this now, right? There is a missing accountability piece, right? So if you make, like in other systems, if you make the counsel's opinions also accountable to the consequence of the opinion. If I'm telling you that you have a very, very good case to win and I don't come good on it, is there an accountability to it? Half the decisions to go to the court will get nipped in the bud. The load on the judicial system is going to come down, right?
Sure.
You tell me which other country where the Supreme Court of that country is loaded as much as it is loaded in this country.
It's being talked about all through.
How many cases actually go to a Supreme Court of the country, right? Is it as high as India, or is there something to learn? Is my short point.
Yeah.
Right? So mediation should absolutely be the inception, not a recourse of saying that, I want to do mediation because litigation is too expensive or too time consuming. Right? You start the way I see it is in any commercial issue or any issue whatsoever, it could be interpersonal issues. There is always two sides to the story, right? You need somebody to tell you that, much that you may think you are always right, but that's not the reality. You are wrong. And I should have the courage to accept saying, yes, I can be wrong. If I'm representing an issue or I'm espousing a cause for Hindalco, it is not that all of my people, all of my systems, all of my processes always work 100% time. And it's always right. It is not even theoretically possible. So unless as an in-house counsel, if somebody brings me a situation, I take a step back and say, hey, tell me what are the things you have done wrong, right? And is that something in the situation of those facts and, situation, forget the law. Something which could have been a mitigatable situation, or you assumed that I can get away with it. If my clients internally tell me that, I actually thought I can get away with it, I will tell them, you know what, I'm not going to litigate this issue. Please talk to the other side and resolve it.
Very
I
important.
will not even take it as much to a mediation.
Sure.
I do one step before mediation saying I'm not even getting there. Because as an in-house counsel, I'm not convinced your facts are correct. I'm not convinced you've done the due diligence properly. I'm not convinced that you have followed the contract you signed to the last word. There is a reason you negotiated the contract so hard and signed it. It is for both sides to follow the contract. You suddenly decide, oh, you know what, the contract doesn't suit me anymore. That's why litigation happens.
Agreed.
So if everybody starts to play the conscience keeper to say that, let me take a step back and think, is it even worth taking it outside the company?
Sure.
And if I'm convinced it is not even worth taking it outside, I will push my clients back and say, talk to the other side, close it. You don't have a case.
Wonderful. So this comes as an answer from a GC, right? Where you have to interact with your own, internal clients and then represent them in the, for the outside world. But prior to that, coming, to this particular aspect as a GC, one small point which I wanted to make, which I heard from you, is somewhere our system, the legal system, which was supposed to be an enabler so that we can maintain a discipline in a society, right, has become a kind of a trap. And I mean, you actually said that, for 10,000 rupees, initially we may not be aware that what we are getting into, but over the period we figure out that, there's a lot of good money chasing bad money now, right, somewhere. But parallelly to this, is it also a mindset issue of the parties? Again, the entire society has developed in a way that, we've been conditioned to think that if we have a problem, if we have a dispute with a third party, then let there be a third party to decide what is good and what is right for me. I'm just, taking away that, I don't want to take the responsibility that, I should be the person who should evaluate the position, who should evaluate the situation, and maybe reach out to, the other party. So as we said, conscious keeper. Your views on this?
Yeah. So Sanjeev, just see it differently. What is a judge? A judge is a third party.
Yeah.
So what is a mediator? He's also a third party.
Agreed.
Mediation is more informal way of what you would otherwise achieve in a court. Okay. You and me are in, let's say, in a disagreement. I'm not using the word dispute consciously. We're in a disagreement. Okay. You're not able to persuade me. I'm not able to persuade you. So we need a third person who can say, you are half wrong and he's half wrong. And you guys need to, as you said in your example, take half orange each and move on. Because this cannot get resolved unless both of you step back and realize that, I'm sorry, I was wrong. That's not happening. That's the reason we are in disagreement or dispute. Now, a mediator is nothing but a judge in a more informal setting, right? You don't have to follow the rigors of filing a court process and have a counsel, stand up in a gown and a band and argue. You're sitting in a more informal, more cordial, in a business center, in a hotel to say that, calling you, sir, kindly help me, right? You're getting somebody who's got a little bit more experience and perspective to tell you, you got to see it differently and you'll see the fact and the truth in the right light.
Sure. So
a mediator is a third party. So, for example, I call you to say that I got this issue. Can you just throw some light on who's wrong here? It may not, I don't even want to call it a mediation. I just respect you because you're a champion for the cause or you're an industry leader or a subject matter expert. And, maybe I'm missing the point. Maybe I'm a little, myopic in appreciating that I can be wrong.
Right.
In my own appreciation of facts, somewhere I'm getting blindsided on it. Somebody who can actually open my eyes and say that just see it in the right perspective, you will see you are wrong. You're at least partly wrong, if not entirely. You have suffered a loss, but it is not entirely due to the other side. Half of it is because of yourself. In your mind, you need to be paid $1 million, but half of it is because of your own wrong. So you're not entitled more than $500,000. So that perspective is brought by a third party. Call him a judge, call him a mediator.
True. But then one small difference, which is otherwise a very significant difference, is judge gets into adjudication.
No,
and mediator
use
makes
language.
parties to decide on their own.
No.
Bridges the gap.
You see, we are just using these fancy words to create a distinction between a mediation and a judge-led process. Judge adjudicates, mediator facilitates. What is the difference? Nothing. Right? A court is a more formal process. You'll quote a CPC, you'll quote an arbitration act, you'll quote judicial precedents. It becomes a little bit more stiff-necked approach. I'm in an adversarial process. Therefore, you've got to have a battery of lawyers, senior counsels and all that. In a mediation, you're not that stiff-necked. You're coming with a mindset saying, I'm here to find a solution. You're not throwing law books and precedences on the other side.
Agree.
You're just arguing on facts and facts and facts, nothing more than fact. There is a contract, there is a performance, there is a deviation or a deficiency on it, there is a potential or assumed loss. How far that goes to one way or the other, that's your right. You're not being stiff-necked. I would rather have my technical people sit in a mediation and negotiate, because I will not be able to add value to an engineering contract, for example. I will have no basis of arguing, saying so much of this and so much of that, which is all technical. I'm not the guy. I'll have an engineering person from, I don't know, the Institute of Engineers to sit and mediate, because that's a technical issue. How much of this is right, how much of that is wrong, there's no law in this at all. The moment I take the same dispute to a court, I'll need a different bunch of people. I will need an expert called an engineer, the same guy, who will stand and give witness, cross-examine, he's right or I'm right. I will throw 4 witnesses, expert witnesses at you, you will throw 4 at me. Finally, the judge is trying to dissect the problem and crunch it down to saying, okay, this is the issue. Otherwise, the rest of it is noise. But I want to really superimpose you with so much noise that you get lost in it. Therefore, it takes forever.
True.
In a mediation, you're sitting in a more cordial setup. You're not throwing books and precedences on each other. You're debating the fact. I had to sell you an equipment which was supposed to perform this way for this duration of time, and this is how the efficiency of the equipment is to be measured. Let's chase it. Did it deliver or did it not deliver? That's a short point. I believe it did not. Maybe I didn't run it properly. Right. You believe it absolutely does. Let me show you it does. And you demonstrate it to me, it still does. I'm now thinking, oops, maybe I didn't use it well. Maybe it's as simple as that.
Right. So the whole idea of this initiative is that, we try and reach out to various stakeholders who have a role to play in this concept or the subject of mediation. Now, the mindset you speak about, a perspective, which is a fresh perspective, no baggage perspective, collaborative approach. How, as per you, some extra efforts or initiatives or action steps need to be taken so that people start embracing it? Because for them, or for a lot of them, awareness is an issue. For example, now, as we speak, Parliament is debating on the mediation bill, right? Would this codification of a law like mediation or a subject like mediation, would it help the cause? On one side, we'll have something on record, but then
the moment you make it anything codified, you're again making it rigid.
Absolutely. So, that was the point.
I will start my arbitration clause in the contract will now start with mediation as per section so-and-so of the Mediation Act, followed by section this of Arbitration Act and that of civil procedure.
Agreed.
You're again getting stuck in the same issue. What I'm doing, we are going to implement, we have already started it in some parts in the Aditya Birla group. I can talk about it in Hindalco. I've started to include now clauses which will perforce offer a mediation for any solution, any dispute or any disagreement, right? Like, forget about a dispute. A disagreement before it becomes a dispute, okay? I'm offering to all my counterparties that I will go for a mediation and the outcome of the mediation is going to be binding on me. You can choose to disagree with the mediation, still go to a dispute resolution. If the mediator, once I refer a dispute to a mediator and the mediator finds I'm wrong, I will not question it. If you start implementing that, half your litigations will go up.
Wonderful.
Right? It
Great.
starts with me, right?
Right. Yeah.
I appoint a mediator. The mediator is trying to help me and the counterparty to come to senses and see the facts as they ought to be seen. And I disagree with the mediator. What is the point of going to a mediator?
Right.
It is like going for a sole arbitration and I disagree with you.
Yeah.
You chose the person.
That
chose
is
the person because I think he has got more experience and wisdom.
Yeah.
To dissect the problem and tell me where exactly, narrow it down to say this is the problem and I think you're partly wrong and he's partly wrong. Find a way to do it. I'm saying, no, I disagree with you. I'm going to challenge it.
Right.
Because
so the onus is on us because we've chosen a particular platform and a process. So also I would say that, be it mediator or arbitrator or the judge for that matter, all the three are expected to be neutral and, independent and impartial from that perspective and unbiased. So point taken. Coming to your role as a GC in a setup, how easy or difficult it is for your in-house clients, the CFO and the CEO, because, again, for them, they've been seen like, it's easy to pick the beaten path, right? We've been doing it. It's been happening. So why I should try something which either is not backed by a codification or a law, or what about the enforcement? Tomorrow I will be questioned why I agreed. I could have won the case differently rather than settling all those things. Do you face these problems? How difficult or easy it is?
Not really. See, one is that, if you start misrepresenting to your own management, saying that, oh, any case, bring it to me, I will take it to the court and I'm going to win it hands down. Stop promising wrong things. As I said in the beginning, we are contributors to the entire chaos or overload of work in the courts. Right? You start being sensible. In the last, I don't know, even before COVID, I don't recall having gone to court on a civil commercial dispute in the last 3 years. I haven't filed any matter in the court. Okay. You start really doing the, gate check for yourself to say that if you stand back and look at it dispassionately, these facts, do you even have a hope in hell to win? Are you entirely right and the other side is entirely wrong? That is not even, possible theoretically. Something has resulted in a dispute or a disagreement which is potentially heading to litigation is a contributory issue.
Right.
You are as much guilty of, running down the contract to a stalemate as much as the other side. It is never that one side is entirely right, the other side is entirely wrong. It is not even theoretically possible. You step back and check. There are some things you may have written communications. The problem is communication, right?
Yes.
Then once you read a contract, once you write a contract, once you read it, you cannot, introduce definitions and meanings to it that was not even intended.
In hindsight, just to try and prove.
Now, I have written I've inherited a contract which was written by maybe my predecessors. Suddenly, I tried to become wiser, saying this is badly written. I would have written it differently. This is how it should be. It is irrelevant.
Yeah.
It is a contract, and that has got to be performed the way it is. Now, you don't like the way it is. Go across to the other side, handshake with them, saying, "Can we do an addendum to it? Because this is now serving the intended purpose. This is potentially heading towards a litigation. Can we rewrite the document?
Right.
Can we make some changes to make it work?" I'm sure any business person would be more than open to see a reason to it, rather than saying, "I want to stick to what was written 5 years ago. I don't want to get wiser by hindsight, and I want to litigate." Nobody wants to do that. Nobody. It is only when we start making false promises, because to me, as I said, I'm accountable for every decision I take. If I tell my clients internally saying, "You're going to win," and I lose, I'm accountable for it. We all take the conscious decision to say that if I'm going to advise my client, internal or external, to say that if I'm going to advise, you are going to win this brief absolutely hands down, and I got the facts right, I got the law right. There's no way any judge can see it any differently. Sure. But then you got to be accountable for it.
Comes from within. That clarity of thought. That's I think. Okay. So I heard you said for last 3 years, you've not been really approaching courts, not filing cases. which, and also you said, and very rightly, that the contracts were drawn and executed in a certain set of situation. The context changes, right? We are all in a pretty dynamic situation, volatile situation. So, the context changes. And the best way is to say that, okay, now some clauses are not relevant or they have become inappropriate for today's context. Why don't we sit and review this entire thing? What is the response of the other side? Because what the concern here is, you have a mindset, you are clear, amazing clarity of thought, that you also say that we are contributories to the mess and the situation currently. So you help your in-house client accordingly. But once you have to interact with the other side, you end up talking to your counterparts more likely than not, which is again the legal or the GC of the other side. Now, do you think those people are sitting with the same mindset, or that's where we have a roadblock at times?
Yeah. It's an interesting question, Sanjeev, right? If I believe what I used to buy for the price that I used to buy when I was a kid, I'll get the same when I'm at this age now, right? It is a bit of a myth.
Yeah.
Now, you want to address a change of fact, change of situation on the ground, or change scope of work, or what you agreed 5 years ago is not meeting your current requirement, therefore I need a tweaking, and that all of that is going to come free of cost. That's where you're losing the connection with the counterpart. You got to go with open mind, saying, you know what, I'm redefining the fact so that it is relevant. If I want you to deliver this to me, and what we agreed has changed, the perspectives have changed, the realities have changed, the technology has changed, I need a different intervention,
right,
for me to achieve the end state that I described 5 years ago. When the contract comes to an end, it requires some tweaking, but I want you to do it at the same cost that you agreed 5 years ago. Not going to happen. You will have to go with the open mind, saying, I don't have an open checkbook, but I'm willing to see reason, saying that, okay, you're saying, fine, let's change the scope a little bit, tweak it a little bit for us to get the desired end state. At 10% of the original contract value, that's the cost. Now we are negotiating on, we are ad idem on saying there is a requirement of change, right? One step done, one tick done. There is a cost. Now the question is, you want 10% of the original cost. I'm saying, I think around 7% is the reasonable. Now you're talking numbers.
Numbers, right.
Nobody is going to dig his heels saying, I will not renegotiate this at all. Everybody is prudent, commercially prudent person. He also wants to execute something for a company like mine to say in his resume, in his website, to say, I did this great project for Hindalco. That's the end state, right? We are in it for a commercial gain.
Sure.
So if I'm able to make the changes to the scope or redefine the goalpost, and also be willing to put the cash on the table to say, I understand the change of goalpost is going to cost this much more, and what is therefore reasonable. If I'm making a reasonable proposition, I'm sure you'll be reasonable to agree and see reason. It's going to take an engagement.
Right.
If you go with the mindset saying, you know what, either you do this or else, you say, sure, or else we'll see you in the court. That cannot be the approach.
True. Yeah. So time and again, the terminology or the nomenclature we get to use is the mindset. And I think that's probably the key at times. And yes, a holistic approach is required for both those parties to sit. A very interesting, question which keeps coming up. If one of the parties is in a dominant position, right? Now, howsoever you might be wanting to sound logical or be open to negotiation or whatever it might be, and you don't want to get into litigation, but you are well assured that because of the brand, the position, and the dominance you have at a particular point in time, you say, no, I mean, I don't need, to engage in a dialogue because I'm pretty good sitting where I am, and I'm not going to lose, based on the contract or situation or my muscle power or the whatever it might be. So dominance probably has, much more ways to be explained. So it may not have a conclusive answer but still I would wanted to have, your views on this thing in case a situation like this arises, whether you are in a dominant position or the other side. Do you think it becomes a challenge to then invite them and engage them and sit across the table?
I don't know what you mean when you use the word dominant, but I will say, let's say it is an unfair negotiation, position between the parties to a contract. It is never unfair. You got to just be more persistent in some situations and less in some others. And in my experience of being in this profession for a while, I can tell you I've never had a situation where somebody really dug their heels saying my way or highway. Right? Please understand, this is a commercial business. I can burn bridges with you today, right? But I'll need you again someday tomorrow. Our paths will cross. Number one. Number two, in today's situation, there is I can't even top of mind think of something which is a one person, one company solution, and there's nobody in the world who's providing something identical or similar. Right? What you provide to me may be slightly superior to somebody else, but it can never be a situation that only you can do it and nobody else can. Unless it is individual contribution by a super specialist who has got that very exact skills which nobody else can. Right? Maybe a patented knowledge which nobody else can do it. But that's a very different situation. But that's not even a bargain, because you're going to a person knowing that only that person can give you this skill and that price is not negotiable. Then again, you're going with an open eye and mind to do a contract and agree on a price for something only that person or that company can only give. Nobody else can. Those are exceptions. But in the general rule, you are never in a situation that this cannot be given by anybody else. I'm sure there are substitutes available, may not be as good, right? So there's nothing called higher bargaining power, right? Even let's assume you're going to a situation where there is the counterparty has got a much higher bargaining power, then you're clear about the fact that nobody else can give what you're going to contract with that party. Right. So it is not that somebody is putting a gun on your head saying it is this or nothing. Walk away. Let me give you a quick, we are kind of out of time, but let me give a quick, I'm sure, all the GCs and all the in-house lawyers do this a lot with their respective businesses. But if you're not doing it, my request to you is that have deeper engagement with your business. Know your business as much as your business managers will. That solves half the problem. The second half of the problem is be engaged in any discussions, negotiations, or conversations from the beginning. 90% of the problem is mitigated at that stage. When you're now writing a contract, your clients are as aligned as you are with the clients. You're not writing a contract once you're handed down a brief to say, this has already been negotiated, these are the terms, and please write a contract. Don't become a document writer. Sure. Be engaged in the entire negotiation process. Spend the time. You will be able to understand the intricacies of what is being contracted for, how will it be delivered, what is the final product going to look like, and whether it is even realistic what you're expecting to write. You write reps, warranties, and obligations, the indemnities and survivals without realizing what does it even mean, right? You start getting involved from the beginning, from the scratch. Even you as a lawyer will not be surprised. Your client will not be surprised. And when the problem happens, you know exactly what you wrote. You're not kind of reading a contract in complete absence of void of facts and everything else saying, okay, I got a contract, now I need to find a way to litigate. You know that the problem lies in us. We need to find a way to mediate this solution out, because in litigation, I'm going to lose.
Right. Yeah.
Your appreciation of fact is way better.
Fair enough. Okay. So the last bit now, which normally, again, we find it slightly a paradoxical situation whereby we end up speaking to mediators, right? Wannabe mediators and existing mediators who've been been doing it for a while. And you check with them and they say parties are not very much aware. They normally do not approach, or they're guided or misguided differently. And you speak to parties in dispute, various stakeholders who are the ultimate beneficiaries, and you end up getting a concern about non-availability of skilled mediators. Now, that's a very awkward situation that there are people who are willing, and then there are people who are not finding the right kind of people. Do you face any such kind of a problem, real life experience? Or your views on this?
It is again, I'm sorry to be repeating myself. This is again a mindset issue. Okay? If I have a pure hardcore science dispute, I'll find a person with that kind of capability to do it. And that person is not going to come with any other baggage but science. If I have a construction, civil engineering issue, why would I go to somebody who I need to teach first? I'll rather go to an expert who knows what I'm talking about. We don't have to always find, we also get into this thing of saying, I went to the most expensive person I could find to do this right. go to the person who's the most competent person to do it. It can be an engineer, it can be a chartered accountant, it can be a more experienced lawyer than yourself, it can be a retired judge, right? It can be a scientist. I have a problem with a particular agreement for something to do with chemicals. Why would I go to anybody else other than a chemical engineer or a person who's an expert in that field? It just truncates the entire issue because this guy is going to focus on the core science of it. Right? I have never had a situation where I don't find the right mediator. I don't even know what that means.
Point taken. You've been using mediators, you've been inviting third-party mediators, independent guys for your own this thing. Is it a regular thing? Are there SOPs which are already evolved on this?
Yeah, I have a clear SOP on it, but the first port of call is internal. If we believe that we have tried to solve it with the counterparty and it now requires an independent third person, then we go for external. Otherwise, we try and talk to each other and sit across the table and I'm sure there is nothing which cannot be solved by just looking into each other's eyes and solving it.
So essentially negotiation, then succeeded by mediation, if at all a third party is required, and then of course the other alternatives. And the last bit, again, it's a follow-up. Now, when you said for a problem in science or a chemical, you would expect an expert. You really feel that the mediator has to be a subject matter expert or more a process expert? Because that's again a debate which has been there.
No, I'm very clear. Mediation has to be subject matter. You don't see the moment you put a process rigor around it.
Yeah.
Then what is the difference between an arbitration under the Arbitration Conciliation Act or mediation? What is the difference? You're again clothing it with guardrails of, it has to be in a legal paper, A4 size, double spaced, bounded like this. You're just killing yourself on process.
Okay, so the point here was not getting into the process of the court or the procedures, but the process with regards to allowing both the parties to speak, bridge the gap, and there has been a skill set.
Any fair-minded mediator, moment you appoint somebody saying, Mr. Sanjeev Ahuja, you are the mediator and I want you to help me resolve it.
Yeah.
Then I have already, entrusted my faith on you to solve it. Now I got to follow. You can't say that, no, you are being unfair. I am the one who chose you, right? If I don't even trust you, then I got to move on and find somebody else I trust. If I trust you, then I got to follow my, gut on it to say that I'm going to place everything fairly and squarely before him, and I'm sure he's going to do a good job. The question is, why are you doing mediation? Is it a tick in the box to say, okay, I've done mediation, now I'll go to arbitration? Or I'm really meaning to solve
you mean it? Yeah, agreed. But okay, but then the only thing which again, slightly needs to be explained is, unlike arbitration, where you have arbitral tribunal and both the parties start with their own arbitrator nominated, and then they together probably look at a presiding arbitrator. But in a mediation, normally if it's a sole mediator, which normally is the case currently, unless until we speak about a co-mediation. So for a sole mediator, how easy or difficult would be only one party choosing, and then he not running the risk of being biased or influenced? Because from the other party's perspective, I think is going to be important. It's a situation of a sole arbitrator for that matter. Both the parties need to be okay. I don't know. Look, these are the queries which keep coming across.
It's a very paradoxical situation, right?
Quite likely.
I have a mediator, you have a mediator, and the mediators choose another mediator to mediate between the mediators. Why are we even doing it? Let's go litigate.
True.
If I am in consensus with you that we will explore a mediation, the first step towards that is to find the most respectable person in the trade profession industry.
Agree.
To show us the way.
Right.
I may not agree with that mediation. I may still think that the mediator didn't get the problem in hand because the answer is giving me is not suiting me.
Sure.
Then you do arbitration. Why even waste your time doing mediation?
Well said. So
I will choose a mediator.
Yeah.
Then there will be a mediator to choose the mediators. I mean, come on. You're just beating the entire process out.
No, that's interesting. So essentially, I think the missing part was the trust deficit. If the parties very well are trying to communicate with each other and they're saying, okay, let us try and mediate or resolve, either directly, as you said, you normally opt for that, or through a third party, which is a mediation. In that case, irrespective whether it's being nominated by you or the other party, till the time you guys are wanting to talk to each other through a third party as an enabler, I think we're good.
Yeah. See, Sanjeev, the question is, how far in the loss of trust you are before you made the call to go for mediation.
Yes.
The very earliest you do when you see signs of fracture, that's when
Yes.
mediation should happen. If you're too
That's
far into the dispute, then mediation is just a tick in the box.
I get that. No, that's very well said, and that's definitely an insight that either the moment there is an attempt or an initiative taken by either of them, and the other party plays ball, then I think the nomination of that individual or third party would not matter because the parties are willing to speak. So he's just an enabler from that perspective.
I've had situations where we have some of the contracts which are more technical contract. We have a CEO-led mediation, right? My CEO will talk to the counterparty CEO, and I've had situations getting resolved in a 30-minute conversation because the way it is like the blind man and elephant story of what the contract is supposed to mean.
Agreed.
At that higher level, they're able to see the objectivity of it. They say, okay, there is a cost issue or there is a clarity issue sorted. And I've had situations where it just got resolved in a 30-minute head-to-head conversation between the two CEOs, and we never had to dispute anything.
Got it. No, that's the need of the hour. In fact, that's what we try and keep pushing, that till the time you want support from a mediator as a party, then it becomes a negotiation. All for it. But the moment both the parties are agreeing, then that's the true mediation where you sit in between. And the last bit, we have heard about a court annexed mediation. What is a private mediation? A court annexed to me is something where you've already taken a certain course, and halfway through you're getting frustrated, and the bench is prodding you to try it out. Do you see a similarity, or it's just a fait accompli, that again a tick in the box?
It's a fait accompli, right? Because the court is now seeing the futility of this continuing in the court. They're again nudging you to go and see reason. But by the time so much of blood has been spilled,
absolutely,
you really don't want to backtrack and saying, okay, I spent $1 lakh to recover 10,000. Okay, I'll settle for 2. You're just doing it because the judge is kind of prodding you to see reason.
So it might be a request, but it's a diktat at the day end.
No, but the judge is also trying his job to help you see reason.
True.
Right? When you refuse to see reason, what can the judge do? He'll say, okay, come back to the court, we'll find.
Perfect, sir. So I think that was all from my side, and that was really enlightening. I mean, of course, you spoke from heart, and you're very clear about the concept and the clarity you have. And this is something which really, helps us to take this initiative forward, because as a GC, as a representative of your own, setup for a third party from the outside world, you are so important a piece where you are letting the disputes and disagreements really go out of the proportion, or you are containing them to the extent you can. And similarly, we speak to mediators and the parties directly. And that's the reason we have, the questions which are coming from all the sides. But I think that was wonderful. So thank you from my side for taking out time.
Thank you.
And last words.
Have fun. Mediate more. Avoid going to the court as much as you possibly can.
Okay. Coming from a GC, and I'm sure your legal professionals will agree with you to the extent they can.
I'm sure the in-house guys will definitely
do. Okay, great. So thanks a lot, Shankar.
Thank you very much. Thank you very much, and thank you for having me on this one.
Thank you.
Bye-bye.